car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
And welcome to the attorneys. I'm Art Franklin. Today we're discussing a situation that many of us hope that we should never face, but just in case, you got to be prepared for it if you are involved in a car wreck. That's something that we really want to talk about. But first, I want to tell you that attorneys for Hollis, Wright, they're standing by right now to take your call. As always, they stand by at the beginning of the call and at the beginning of the show. And that number is 1-844 Law Talk. It is a free call. It is a confidential call, and you can make that right now. Josh Wright, good to see you again, buddy.
Great to see you too. Hope you had a great week.
I did indeed. And we got a special guest with us today, Mason Osborne. Good to be with us.
Yeah, good to be with
you. You know, one of the interesting things that people may not know and why we do enough of the personal injury cases related to auto accidents, uninsured motorists shows is that in a typical year, you have 31 to 35,000 accidents in Alabama. About 600 of those equate to death. A huge majority of those relate to some type of injury. So there are a lot of people that go through this moment, whether they desire to or not, and we try and provide some level of information to them on kind of what to do after an accident. And that's really what Mason's going to be talking about. Mason, just talk a little bit about the firm you work at, who obviously we know real well, and I'm sure the viewing public will. Tell us a little bit about your practice and your firm.
So, like you said, my name is Mason Osborne. I'm an attorney with Alexander Shannara Trial Attorneys, and basically, you know, my general practice is probably 4 areas. You know, automobile accidents, premises liability cases, trucking, and then, you know, types of dog bite cases whenever we get them through. So that's kind of the area that I specialize in, and that what I've been working in here lately.
So let's kind of jump off from the start here related to auto accidents. What are you seeing, kind of what trends are you seeing, and what do people need to do when they want help after an accident?
Well, what we're seeing a lot right now is that, and you know, to be quite frank, a lot of times I've had clients reach out to me 2-3 days after the wreck, and they've already gotten calls either from the adverse insurance company or from an adjuster. And just recently I had a case that came through where I'd spoke with my clients, and I spoke with the adjuster for the person that caused the wreck, the insurance adjuster, and they had already went out and met with my clients. And this was up in North Alabama. So I'm seeing them being very proactive, and that's why I try to tell my clients is that the first line of defense is really them, because when something like this happens, you don't expect it. You're not going to have your attorney there with you. You might even be alone, and it's important for us to realize that from the time that that happens, from the time that, you know, someone's put on notice that you've been involved in a wreck, they're already investigating the case. They're already making their case, and that's why it's so critical that, you know, you involve an attorney if you think you need it, so that we can get in there and we can get our hands involved in stuff, so that they're not directly speaking with you, you know, doing recorded conversations, asking you for your medical records. So I'm seeing a lot of proactivity from that side, which kind of in turn requires us to be more proactive.
Yeah, and you know, one of the things I'm also seeing too, just like Mason, is carriers that are with the adverse party or with the at-fault carrier trying to get immediate statements before lawyers get involved. And that can be very dangerous. You know, people do not realize that you've got an obligation contractually to provide information to your own insurance carrier and to provide statements to them. But even in those circumstances, and we're not talking about the at-fault carrier that is the one that caused the accident, but your own carrier, even in those circumstances, you have a duty to your own insurance carrier, but you need to get a lawyer involved quickly. You know, we talk about these concepts of get a lawyer, you know, let them help you. They're going to give you the same quality of legal services. You know, we don't spend a lot of time on is contingency fee contracts.
Right.
And just explain for a moment, because I know you have to do this with your practice all the time, how someone can get the same quality of legal service on the plaintiff side that the insurance company is going to provide through a contingency agreement and kind of generally how that works?
Well, a contingency agreement basically is just, you hear, you've heard people talk about it, is that, you don't pay unless we win type of agreement where we're going to front the cost or do whatever we need to do to help you preserve your case. And then with the contingency agreement being a certain percentage from the gross settlement, that's what would come out as far as payment on the back end. Yeah. So let's say a case doesn't settle, or maybe it's a case that, for whatever reason needs to be turned down. Maybe there's an issue there. It's not going to be a cost that our clients absorb unless we settle the case. And depending upon what stage of litigation you're in is depending upon, the fee percentage of the contract. And it might be, lower or higher depending upon if we go all the way to trial to a jury verdict, or if we settle your case, a month or so after you sign with us, just in pre-litigation. So that's kind of the distinction there. And
these conversations with lawyers to start with, even if you don't want to sign a contingency fee agreement, are free.
Right.
So go talk to someone, right?
Absolutely. Someone else that you will probably end up talking to will be the insurance companies, right? Yeah. And I think you kind of started down this road a few seconds ago, but if you would, talk about the types of things that you should be saying, because people can make a lot of mistakes at that early stage of the game.
Yeah, so my first recommendation will be if the adverse insurance carrier calls you, don't talk to them. If you have an attorney, tell them that you have a lawyer. If they ask for a recorded statement, that should be a signal right off the bat that you need some type of representation. Because these adjusters, they're trained almost similarly to how an attorney's trained. And I've listened to recorded statements from clients that I've had where they are basically giving a free deposition to the insurance carrier and giving them 2 bites at the apple. So we'll have the recorded statement pre-litigation that they don't really know is going to be held against them later. And then, you get past filing the complaint and you get into party depositions where now they get, with a lawyer, a second bite at the apple after they've already interviewed you once. And even if you don't mean to be inconsistent, or even if you don't mean to, tell them something that maybe you don't remember because you've just been in a wreck, they're going to use those inconsistencies against you. So it's really important not to give them those 2 bites at the apple.
And I would say too, and I know Mason can agree with this, there are 3 states in the District of Columbia that support contributory negligence as a defense. We talk about that on other shows, but the simple way to look at that is even 1% responsibility of the driver as a contribution to the accident itself, maybe going over the speed limit, failing to yield completely, even if someone is at fault that wasn't you. If you contributed to that accident, you can be completely barred from recovery. Now, lawyers know, and Mason knows too, there are ways around that, and that's why you get a lawyer involved. However, contributory negligence is a potential bar. So you don't want to give a statement where contributory negligence could potentially be an issue that you walk into unwillingly and not knowing what you're doing, where you could eliminate or limit the value of your case. In addition, one of the other things that we see a lot of is people go into these statements and they may not have fully evaluated the medical side of their injury yet. And then all of a sudden, what happens is a month later, they end up with consistent pain. It gets an MRI, they have a herniation, they need surgery, and they talked away the value of their claim on the front end. And I know that's got to be something you see too.
Yeah, and I can't tell you how many, orthopedic surgeons that I've taken the deposition of where they'll testify to this. They'll say, it's common in our practice that maybe you're involved in a wreck, you're involved in some type of injury, and the pain from that or the symptoms from that, the onset isn't until maybe 7-8 days later.
Yep.
And if you get that recorded statement or you say something like, well, I'm fine, there's nothing wrong with me, well, then you've got that inconsistency that they're just trying to, hamstring you on over and over. So, that's backed up by not just us saying it, that's by physicians saying that.
So we're about to go to break. When we get back, I want to talk about the importance of accident reports and what role you can play in making sure the accident report is identifying the correct stuff in your accident. Let's talk about that when we come back.
What to do if you are involved in an accident. We are giving you really good information right here on The Attorneys. As we head to break, I want to remind you there is a QR code on your screen. Scan that QR code, and you can reach someone at Hollis Wright right now. Anytime you call during the show, 1-844-LAW-TALK, Guess what? It's a free and confidential call. We'll continue with this discussion right after the break. We'll be back after this.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best: help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys. Injuries you sustain in an accident don't define who you are, but the firm you choose will. Choose wisely and select a firm with over 20 years of success of winning personal injury cases. Let Hollis Wright tell your comeback story.
Welcome back to The Attorneys. I want to let you know we're talking about what to do if you are involved in an accident. But before we get back to our topic that we were talking about just a few minutes ago, I want to remind you that you can reach someone at Hollis Wright right now at 1-844-LAW-TALK. And that means you can get that information right now. So as we come back, I want to talk about accidents and some of the importance of I lost my
reports.
Of the reports.
Yeah, accident reports. Well, and it's one of the things that we talked about going out to break that I think is so important, because a lot of times, maybe not the value of your case, but certainly the direction your case is going to go in with the at-fault carrier is going to be impacted by accident reports.
Right.
So talk just a minute about accident reports and kind of how that can control your case.
Right. So crash reports or police reports, they have a few different names. Generally, every time you're involved in a wreck, if you call 911, the state trooper, sheriff's deputy, the police officer, whoever shows up, they're going to create a report. And in that report, they're going to have every driver that was driving a vehicle, they're going to have their driver's license number, their address. And the biggest question that I hear from my clients is, well, the accident report said X, but that's not true. Well, first, in Alabama, the police report, a crash report, generally is not admissible. There are statutes on that, case law on that, where that's not going to be something that's presented to the jury. But it's important because that report, and Alabama has fairly, descriptive reports. It's going to give you the insurance carrier of everyone involved, the address of everyone, the phone number of everyone. So I use it as more of a, information gathering tool so that I know who ought to involve in whatever we need to do. Now, I would say I've had one case where there was a wreck happening and an accident report wasn't made, and that's because a tornado was coming through. It kind of made things a little bit more difficult, but that's why I tell my clients, even if the police officer is writing everything down, if you can, get a picture of the other person's driver's license, get a picture of their insurance, documentation if you can, just because in the event that maybe they make a mistake on the report, or maybe the report isn't uploaded to the right, document system, you'll have that. So that's what I use it for.
Yeah, and oftentimes we find circumstances where there was insufficient information at the time of the accident. The officer is doing his best job, but he can only base his narrative of what happened in the accident based on the information he has. So a lot of times what guys like Mason and I are doing is when we're taking that officer's deposition in the case, we're making sure the officer recognizes under oath that, hey, there was insufficient information. If those facts are true, that would change my opinion on what I said in my narrative, right? That happens all the time. Because sometimes officers will stick directly to the narrative, but even an officer that wants to do that, if there's new information, they're going to be open-minded to say, okay, well, hold on, that would change my view a little bit. So having a lawyer lead, guide, and direct you can really impact what your accident report says and how you work your way around an accident report that may not be completely accurate given the real facts and circumstances that develop.
And we talk about those reports and that information that you're getting. Some do's and don'ts in when you're not only documenting that, but also talking to the insurance company and talking to the officers who's writing that report.
Well, I would say there's probably more don'ts than there are do's, right? And naturally, us being in Alabama, everyone's nice. We have, that Southern mentality. So the first thing that happens, no matter if you're at fault or if the other person's at fault, when the accident happens, someone says, "I'm sorry. Are you okay?" Or I didn't mean for this to happen. And it's innocent at the time, but unfortunately, I've seen it more and more where people or defense carriers have used the phrase of my client saying, "I'm sorry this happened," as a way, going back to contributory negligence, of them saying, "Well, why did you say you're sorry if you didn't do anything wrong?" And you don't think about it at the time, and it goes against common sense and even like manners that we talk about. But you just have to be very cognizant about what you say. So whether it be when you're being asked about what happened by the officer, just tell them what you remember. You don't have to apologize. You don't have to say it was my fault just because you're in the heat of the moment. So that's one of the biggest things that I see. Another thing that I see people doing is reacting to someone else being upset or yelling and screaming at them. And one of the things I've seen is, it's the heat of the moment. You're on the side of the interstate. Someone's mad and yelling, and it turns into an argument where it doesn't necessarily have to be that, where it can be a cordial conversation. So the biggest thing is just remember what I say is that you're your first line of defense. And even as a plaintiff, we have to be considering what we can do to defend ourselves in that situation.
So obviously, with the onset of technology, especially cell phones, since the late 90s, early 2000s, we have a lot different ability to document things. Talk just for a second about the importance, when you can, barring a significant injury that you're facing, about documenting things at the scene.
Right, so everyone's heard it, a picture's worth 1,000 words. I'll tell you, when I have a case where there's no photos of the scene, no photos of the injury, and then I have another case where I have photos of the scene, photos of the injuries, those are on two different playing fields, and it might be the same facts and the same objective injuries, but when it comes to establishing our case and kind of showing the jury and putting them at the scene, that's one of the biggest things that I tell my clients. If you can take a picture, take a picture. If you can make a video, because most people, you have iPhones, smartphones, you can video record things, and that's going to give us, first of all, the video is going to capture audio of people talking, right? More than what a photo is going to do. But it's also going to allow the jury or allow the insurance carrier to put themselves in that position to see the dangerousness of what happened or what was going on. So if all possible, that's what I would recommend doing. But of course, there's circumstances where if you're in the back of, an EMS ambulance, you might not have that opportunity. But
and Art, one thing too, I know we're getting ready to go to break, but I see this a lot. I know that Mason and his firm sees it a lot too. Sometimes cars, because clients don't always come immediately to a lawyer, even if they're seeking medical care. They have a real injury. They don't know who to hire. It's intimidating out there to communicate with a lawyer. It's kind of a confused space. There are so many lawyers making different representations to them. So they may sit for a while and be on the sidelines and not get a lawyer involved quickly. Well, guess what? Those vehicles can disappear.
Right.
And the value of a case that identifies the significance of damage to a vehicle versus the value of the same case with no pictures to support the significance of the damage to the vehicle can be drastically different. So documentation, even if it's simply snapping a couple pictures or making sure your officer snaps a couple pictures or making sure someone that comes to pick you up at the scene snaps a couple of pictures can be important. If you can't do it then, make sure it's done after you are done with your medical care. You've got someone that's going to the record service, helping preserve vehicles, et cetera, if lawyers are not involved.
But while we're on the subject of mobile devices, before we go to break, is there a quick answer to social media? Because people will document and then post stuff on social media. How damaging is that?
You know, I tell my clients that one of the first conversations that we have is that I understand social media is part of our everyday life, but it's important that while you have an ongoing case to refrain from posting about details related to what we're representing you for. And that's just because, you know, you never know what's going to happen. You never know who's going to see what. So that's what I say, is that just refrain from posting during the time period you're represented, and you know, that avoids any future issues that I might see.
From our perspective at our firm, one of the first letters or emails you're going to get has a social media policy in it of what the do's and don'ts are to make sure that you don't make a mistake there. But there are times when you still want to post, especially during a recovery. That's allowed. When we come back, though, one of the things I want to talk about, and this happens a lot, are bankruptcy and the impact it can have on a defendant who's at fault that files bankruptcy versus a plaintiff who was injured that files bankruptcy. I want to talk about that because it can play a major role into these cases.
All right, we're going to go ahead and take a break, but since we're on the subject of social media, follow Hollis Wright on all social media platforms, Facebook, X, Twitter, and Instagram. Make sure you do that. You can get some good information there. We're going to take a break. We'll be back with the attorneys after this.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
Hollis Wright has assembled one of the best trial teams in the state of Alabama. A team that doesn't quit, a team that never backs down, a team that has the skills to take your case all the way. Let Hollis Wright tell your comeback story.
Welcome back. Glad that you are staying with us here on The Attorneys as we're discussing car wrecks, the do's and don'ts, and so much that we've been given some good information.
Mason, you've done a fabulous job helping explain to those that are watching the show. Talk a little bit about the implication of bankruptcy and how that applies, because I know your firm and my firm see this more than people realize, and it's important, and people need to recognize that a bankruptcy can have a major impact on a case.
Oh, I mean, it's critical. The biggest thing with bankruptcy that I hear is, well, why does that matter with my case? And I'll tell you that it's important to let your attorney know if you filed bankruptcy before the wreck happened or even during or after the wreck, because basically what happens is that when you file bankruptcy, your bankruptcy attorney can list your personal injury claim as an asset. Okay, Well, if it's not listed as an asset, you might run into certain types of issues depending upon the type of bankruptcy chapter you file, where you might be precluded from having a claim. And if you are in bankruptcy and there are certain things that we look for, but generally, we would have to go as your attorney and apply to the federal bankruptcy court to get approval to represent you on the case. So if we don't know that you're in bankruptcy, or if we're not aware of that, then we might get down to, when we settle the claim, if no one knows you're in bankruptcy, that causes a whole host of issues that I've seen, which is why it's so critical if you've ever filed bankruptcy, or if you plan on filing, or if you have during the course of the litigation, to tell your attorney so we can go through the proper channels to make sure that you're protected and to make sure that your claim is protected.
And Mason's firm, our firm, good firms that do this type of work, they ask appropriate questions at the time of settlement, at the time of distribution about bankruptcy to make sure we don't run into those issues, but letting someone know. Let me give you another component of how this works, and I know that Mason and the Shinar Group sees this just like we do. Sometimes a defendant who caused the accident in a clear liability accident will file bankruptcy. They file after that accident, or they're in bankruptcy at the time of that accident. There are ways with good lawyering that you can work your way around the bankruptcy court and still get to the insurance proceeds you would have been entitled to originally. So it is important to make sure that if you learn information about bankruptcy, either for yourself or for the person that caused the accident, that you need to let your lawyer know.
And before we go, I really want to hit on this one. Hit and runs. If I'm involved in a hit and run, how does that impact me?
Well, first of all, if you're involved in a hit and run, don't chase the person down.
Right.
That's just going to create more of a dangerous situation than we've already seen. If you can, and if you are in a hit and run, call 911, wait at the scene, wait for the officer to get there, and if all possible, snap a picture, if you can, of their license plate. I've had multiple cases where I've had people with hit and runs, and my client took a photo of the license plate, showed it to the officer was able to track them down. It's not you don't have the authority as an individual to go to someone's house and investigate the case, right? That's what the police are there for, that's what the state troopers are there for. So that's what I would recommend you do. And then, I think we're going to talk about uninsured motorist insurance, where if you don't have the opportunity to figure out who was involved in the hit and run, that might be another avenue that we can talk about.
Yeah, we've got about a minute left. Just really quickly unwrap this. I know your firm digs deeper than just the at-fault coverage.
Right.
Uninsured motorist is something that's evaluated. In 30 seconds, just explain generally uninsured motorist.
So uninsured motorist coverage is your own insurance coverage that steps in the place of either an uninsured motorist or a motorist that is underinsured. So let's say they've harmed you, and maybe you have $25,000 or $30,000 in medical bills, and their policy is only $25,000. That might be a position where then you turn to your insurance carrier that you're entitled to, the uninsured motorist benefits that you pay for every month in your policy, to help protect you against any issues that exceed the at-fault driver's insurance coverage.
A+ on the law school exam right there on uninsured motorists in 30 seconds. Hey, great job. Fabulous job. Yeah. I know you do a good job at your law firm. We do a lot of these topics. They're important because there are a lot of people involved. Glad to have Mason on, though.
Yeah, and glad to have you guys joining us here on The Attorneys. And go ahead, schedule it again next week. Make an appointment to catch us once again. The Attorneys will be back here, same place, same time.
Thanks for watching The Attorneys, sponsored by Hollis Wright.